We're going to go ahead and get started. I'd like to welcome everybody and thank you for coming to our panel discussion this evening. My name is David Fidler, and I'm a professor of law here at the Maurer School, and I'll be moderating the discussions. I do want to have a shout out to the Indiana Journal of Global Legal Studies for sponsoring tonight's panel, and thank you for bringing all of this together. We're here this afternoon to explore the effectiveness of international law. Now, that question has long been an important one in international law as well as international relations more broadly. And if you don't believe me, let me just mention that the upcoming American Society of International Law Association meeting in April of this year has selected as its topic of focus the effectiveness of international law. Now, whether international law is effective is not a new question, and long-standing and ongoing efforts to answer the question are, for international lawyers, a source of fascination, a source of frustration, and sometimes a source of anxiety. The topic is fascinating because it allows exploration of how international law operates and how it affects the behavior of state and non-state actors across a diverse and an expanding range of issues. The exploration is frustrating because efforts to answer it confront methodological, legal, and political complexities and controversies that often prevent meaningful conclusions or consensus from forming. The question often produces anxiety for international lawyers because it connects, and I can see one of my colleagues nodding vigorously, it connects with perennial skepticism about international law's role in international and domestic politics. And it also creates anxiety because it highlights the need often for international law to reach out to other disciplines to help answer this question, particularly the discipline of international relations, to find frameworks or theories that help us explain the role of international law or its effectiveness or the lack thereof in world politics. Now, today we have the honor and privilege of hearing from a panel of eminent experts who will all speak with experience on international law as practitioners and as scholars. Now, the need for brief introductions limits what can be said about each of our panelists, but for each of them, even brevity boggles the mind about their expertise and their accomplishments. So let me begin with Her Excellency Judge Joan Donoghue, who is a member of the International Court of Justice, often referred to as the World Court, which is the principal judicial organ of the United Nations. Judge Donoghue has been member of the ICJ since 2010, and prior to this service to the international community, she had a distinguished career in the U.S. Department of State, where, among other posts, she served as the principal deputy legal advisor or the senior career attorney at the Department of State from 2007 to 2010. And during this period, she was also the acting legal advisor of the department from January to June 2009. And in these positions, she advised President Obama and Secretary of State Clinton on many aspects of international law. She's been an adjunct professor at Georgetown University and George Washington University School of Law, and also a scholar with publications on topics as diverse as sovereign immunity, environmental challenges, and the role of the World Court. Judge Donoghue is here at the Maurer School this week as the George P. Smith II Distinguished Visiting Professor, and she's going to focus her remarks this afternoon on the effectiveness of international adjudication. Next, we have someone very familiar to the Maurer School community, Ambassador Feisal Istrabadi. He's a professor of practice at the Maurer School and the School of Global and International Studies here at IU, and who is also the founding director of the IU Center on the Study of the Middle East. Before playing such important roles here at IU, he served as Ambassador Extraordinary and Plenipotentiary, as the Deputy Permanent Representative of Iraq to the United Nations, a position he held from 2004 to 2007. Prior to that diplomatic service, Ambassador Istrabadi acted as a legal advisor to the Iraqi Minister of Foreign Affairs and was the principal legal drafter of Iraq's interim constitution and the law of administration of the state of Iraq for the transitional period. And he was also the principal author of Iraq's Bill of Fundamental Rights. Ambassador Istrabadi will explore the effectiveness of international law in terms of its effect on state conduct, focusing on military interventions to address human rights abuses, with the situation in Syria serving as his case study. Finally, we welcome Professor Yvonne Dutton, who is Associate Professor and a Dean's Fellow at the Indiana University McKinney School of Law in Indianapolis. And although she only joined the McKinney School in 2012, she's already produced an intimidating portfolio of publications on a range of issues, including maritime piracy, international human rights treaties, the International Criminal Court, and the role of enforcement mechanisms in international law. The McKinney School of Law recognized the excellence of her scholarship by awarding her the John S. Grimes Fellowship in 2013. Prior to joining the Academy, Professor Dutton practiced law as a federal prosecutor in the U.S. Attorney's Office for the Southern District of New York, which included trying narcotics trafficking and organized crime cases, and she also practiced as a civil litigator in both New York and California. Professor Dutton will address the effectiveness of international human rights treaties at constraining state behavior and improving a state's human rights performance. And the plan is for each of our panelists to speak for 10 or 15 minutes, and then we're going to open things up for questions and discussion between the audience and the panelists. So I'll now ask Judge Donoghue to start our exploration.
Well, thank you very much for that kind introduction, and thank you to all of you for coming today. I know that you're busy with other things, and I'm grateful for you to take the time out and join us today. I'm going to jump right in. I am a judge on the International Court of Justice, but I have, since joining the court, spent quite a bit of time traveling around the United States talking about international law and international adjudication. When I do so, I get certain questions repeatedly that I've come to recognize. And I get a set of questions from expert audiences and from non-expert audiences, including non-lawyers, that may be framed in different ways, but that sound ultimately like the same question. And essentially, what I have in mind are questions about what happens after the International Court of Justice renders a judgment. Do states comply? If they don't, what are the consequences? How, in effect, do the judgments of the International Court of Justice affect what happens in the real world? And so those are good questions, and they're not simple ones to answer. And just to recall, for those of you who are not necessarily familiar with our court, what do we do? We are the UN's principal judicial organ, and we hear basically two kinds of cases. About 80% of our caseload is what we call contentious cases. Those are cases brought by State A against State B. The question is whether State B violated international law, usually a treaty or customary international law. That's the question we're asked to decide. We don't decide criminal cases. We don't decide the individual accountability. That is something that other courts based in The Hague do. And then we also provide advisory opinions at the request of other organs of the United Nations. So today I'm going to focus on the work that we do in that first batch of cases, the 80% of our cases, the contentious cases. Now, just again, a little more background on those. The UN Charter set up our court as the principal judicial organ of the UN, but it didn't give us automatic jurisdiction over states. We only have jurisdiction when states consent to our court's jurisdiction. And they can do that generally, and about 70 states, so about a third of the states that could do so, have done that. They can consent to the court's jurisdiction in respect to disputes under a particular treaty, or two states can come jointly to our court and ask us to settle a particular known disputes. That's how the cases get to us. What happens after we decide a case? In formal terms, the answer is that the states are bound under the UN Charter by our judgment. They're obligated to implement it. What if they don't? The prevailing state can go to the UN Security Council and ask the Security Council to take action. But in practice, they don't normally do that. There's only been one attempt to do so. How many states comply with judgments of the International Court of Justice? It depends on how you count. Scholars have looked at it. They've engaged in some counting exercises. But roughly, I'd say about 3/4 of our judgments give rise to compliance, and sometimes compliance is quick and relatively easy to achieve. Sometimes it comes slowly. Sometimes it seems clear that the state is interested in complying, would like to do so, but is not in a position to do so, at least for some period of time. That is a comment about compliance. But compliance is not the same as effectiveness. And a good example of that would be a treaty about pollution. So if we have a treaty that's being negotiated and it sets the criteria for the emissions of a particular pollutant really, really high, then you might have states that say, well, we don't want to join that treaty because we are interested in emitting that pollutant at a level that's not as that it wouldn't permit us to meet that very stringent treaty. So they'll stay outside. So that state might stay outside of the treaty. Another state might come into the treaty and become a party to it, but reduce its emissions of that particular pollutant maybe only by 80% of what the treaty required it to reduce. So that state would not be in compliance with that treaty. But if we compare its behavior to the state that stayed outside of the treaty, you might say, well, actually, it's done something that's effective in achieving the goal of the treaty in reducing the pollutant, but it's also not in compliance. On the other hand, we might have had a treaty that had a very generous standard in terms of the emissions of that particular pollutant. And we might have 100% compliance by every party to that treaty, but it'd be difficult to argue that that treaty was effective in addressing that pollutant because it didn't cause reductions because it was a very flexible standard. So that's a difference between compliance and effectiveness in the context of primary norms that are reflected in a treaty. And we see similar distinctions between compliance and effectiveness, I think, when we shift to an international court, because when we look at compliance, we look at the specific question, did the state do what the court told it to do? But the question of effectiveness is different in that what we're looking at when we ask ourselves about compliance with a particular decision, when we shift from compliance to effectiveness, we're looking more broadly at what is the underlying dispute and was that dispute settled? So that causes us to have to think a bit more about why do we have an International Court of Justice? What is the purpose of that court? And there are a variety of ways that one could approach that. But one way to think about it is to look at what were the goals of those who set up the International Court of Justice. And you can derive, I think, 4 goals from the functions that were given to the court. The first is the settlement of particular state-to-state disputes peacefully in accordance with international law. The second is assistance to other UN organs through advisory opinions. The third is the development of international law in the course of performing those 2 functions. And the fourth is that the work of the International Court of Justice inevitably would shape the behavior of states that were not parties to the particular dispute. Because if you set up a court of first instance of 15 judges, it's not under any scenario going to decide hundreds of cases a year. It's not going to directly address the overwhelming number of disputes that arise in the world over a year. So its potency must derive in part from the way that its decisions, the way that its jurisprudence is used to influence and shape behavior of states in conflicts that are not directly before the court. So if we want to understand the effectiveness of the International Court of Justice, we have to do so with reference to all four of those functions, all four of those goals that were assigned by the mandate providers. But today, I just want to zero in on the particular goal of the peaceful settlement of particular disputes, just a piece of what the court was asked to do. And I just want to ask 5 questions about that. And the reason I pose these as questions is because I don't know the answers to them. So what I have hoped to do as I speak to academic audiences around the country is to stimulate greater interest in studying these questions. So my 5 questions are as follows. The first question is a factual one. What happens after a court like the ICJ renders a judgment? And you might think, well, how do we know? You should know the answer to that. You're a judge. Well, when we decide the cases and we're done with them, they go off of our docket. We don't have a mechanism to follow cases. We don't monitor what happens. So I might be able to figure out what happened, but so could you. So just the basic facts about what happened after a judgment is rendered are not always available publicly. Now, what if we do have the facts and we look and we see that, gee, it looks like there was a change in state behavior in the aftermath of a judgment? Then how do we determine whether or not the judgment caused the behavior? There could have been other factors that contributed to that change in behavior. How do we dissect those? What methodology should be used to answer that question? Then if we think there is a causal link between an ICJ judgment and a change in behavior on the part of one or two of the state's parties, what explains that link? What theories of international relations, what ideas about the behaviors of states best explain the relationship of that state conduct to the court decisions? My 4th question, can any conclusions be drawn about the kinds of judgments that are more likely or less likely to be effective in settling a dispute peacefully? For example, does the specificity of the ICJ's remedy make a difference? Does the size of our majority seem like it could have an impact? Does it matter whether our judgment is a winner-take-all outcome or something that's a bit of a mixed bag where each side feels like it won something and lost something? And my last question, and this is an important one, is how does the effectiveness of the judgments of an international court compare with the effectiveness of other authoritative pronouncements, such as a report from a UN treaty body or a special rapporteur? Our court was set up as a judicial organ. We perform certain functions. There are many other courts out there that perform functions similar to ours, but there are also non-courts that make pronouncements about international law and findings of fact. Our conclusions are binding on the states. Does that seem to make a difference? I don't know the answer to that, and it needs further study. So what I've tried to do is just identify 5 questions that I think are hard questions that I'm asking about only one of the functions assigned to our court. And as I said, my goal is to hope that I can invite further inquiry on the part of those who have time to pursue these sorts of questions in their academic work. I'll stop there and thank you very much.
Okay, thank you. Ambassador Istrabadi.
Well, thank you very much. It's a pleasure to be on this very distinguished panel. Actually, question of the effectiveness of international law is causing me anxiety right now. In this very distinguished panel, I feel, as the old chestnut goes, as if I'm the brown suit at a black tie function. But be that as it may, it's a privilege to be with this panel. And I want to thank also Judge Donoghue for having addressed my class yesterday. It was, I think, a delightful opportunity for my students. I should say, and I don't know that he will want to be acknowledged at this point, but some of the thoughts that that I've been thinking about some of these issues for some time arose actually in a conversation that I had with Professor Tim Waters after a lecture here by Professor Coe. And while one often sort of nods as Tim is speaking, as if in a foreign language, these sophisticated thoughts that one is trying to keep up with. I don't mean to tag him with any mistakes I might make, but he has been a delightful colleague and one who has stimulated a lot of thoughts on my part, including some of the things I've been thinking about for the purposes of this panel, and I wanted to acknowledge that. What I think I want to address is the effectiveness of international law in terms of certain parameters. And for me, sort of viewing these issues always from the perspective of having been something of a practitioner over a period of at least a few years after the war in Iraq in 2003. What interests me most is the question of the sort of the predictability, and I don't know how else to phrase it, the predictability of state conduct in terms of, and of viewing the effectiveness of international law through that prism. I take it that effective legal mechanisms have some correlation to conduct. I take it that I don't drive 70 miles an hour down 3rd Street, even at an hour when there is no traffic there to speak of, because there's still a chance I might get a ticket and I make the calculation. And therefore, my conduct is affected accordingly. Now, I understand that in the case of international law, it is, I think we would sort of concede together that it is more of an attenuated relationship between conduct and the legal principle. I take it that we would agree that that's the nature of international law, or at least often the nature of international law. And I think that is telling us something about the nature of international law, and surely must be saying something about the effectiveness of international law at the same time. And I will explore that more fully, as was said earlier, in the context I know best, which is the whirlwind of the Middle East. I do think it's fair to infer that if we could agree that, as with any other area of law, if international law is perceived as being effective, then I ought to be able to find some correspondence that avoids my having to find a noun with state conduct. I will look at the issue of military interventions in light of gross human rights abuses, because it seems to me that that is the intersection of two broad fields, broadly regulated, or rather extensively regulated by international law. And my argument will be that politics and national interest continues to be a better predictor of state conduct than international law, and that to me suggests that the law is still in its adolescence, at least as a meaningful tool with respect to international relations. And I've actually decided not only to talk about Syria, but to talk about Syria in light of Libya. Two recent interventions or non-interventions that fit the criteria of the intersection that I spoke of. Now, there is an internationally agreed mechanism for vindicating international legal norms, at least those that threaten peace and security, or international peace and security, as that term is used in the Charter of the United Nations. And, of course, that agreed mechanism is at the United Nations Security Council. not a judicial body, obviously, but one that has a profound implication for a variety of legal issues. And just to cite very quickly, two sources for that assertion, it would be the 2005 World Summit Outcome document and the 2004 report of the High-Level Panel on Threats, Challenges, and Change, whose authors were appointed in light of the U.S.-UK war, intervention, whatever word you like to use, in Iraq in 2004, and this was Kofi Annan's response to what he later asserted was an illegal war. Again, both those documents would sort of have some international legitimacy in that, you know, the one document is sort of signed on to by all the heads of state of the world, more or less, at least of the member states. And the other has the imprimatur of the Secretary General of the United Nations. Both agree that it is a Security Council that ought to be the body that authorizes the use of force in instances in which gross violations of international human rights law have occurred. Well, the fact of the matter is the United Nations Security Council is designed to work only when there's consensus amongst the 5 permanent members. That's a statement that requires no further proof. There's a veto. 5 members have a veto. So 1 member doesn't agree, that's the end, and that's by design. That's not an accident, that didn't arise through custom, that's by design, that's in the charter. So if that's the case, then that means that ipso facto, at least on what is agreed, so we're not arguing at the moment about what is and isn't customary law and all that, but what is agreed by the international community means that is the agreed mechanism, means that a priori it means there has to be a political consensus to reach, to get to the level of action, even to address the gravest violations of human rights norms. It's popular and to argue, well, let me not use the word popular. One hears the argument that, and in fact we did hear when Professor Coe came through, and this is what engendered the conversation with Professor Waters. The argument, well, the Security Council's deadlocked, so we have to find some alternate mechanism to make the world system work. The problem is the deadlock is a part of the world system when there's not a, and as I again say, by design, when there is no consensus, no political consensus on the part of the 5 permanent members. By the way, the elected members, who are formally referred to as the E10 as opposed to the P5, in fact refer to themselves as the L10, the little 10. And when there is consensus on the part of the P5, the L10 come along just fine. Thank you very much. For instance, and now let me get a little bit into the Middle East, a part of the world I know best. It has been argued by Professor Coe that the Security Council was deadlocked over Syria. And in some sense, of course, he's right. 2 resolutions that would have authorized action in Syria were vetoed by Russia and China. But I don't think it's correct to say that the Security Council failed to act in Syria. The Security Council, in light of circumstances I will describe in a few moments, considered the issues, debated the issues, had at least 2 final drafts, proposed final drafts of resolutions, which had gone through multiple modifications over much contestation, but it simply could not garner a political consensus. That's not inaction, I would argue. I don't have time today to develop that argument, but let me move on from there. The fact you didn't like what it did doesn't mean it didn't act. You could say, well, from a legal perspective, it must be that the Security Council couldn't agree that there was a threat to international peace and security, and therefore it would naturally not authorize. But that isn't the argument I am going to be making in a few minutes. Nonetheless, I maintain it in fact worked, and the international system in that instance worked the way it was designed to work. When there was no consensus, no action, i.e. military action, was authorized. Now let's look at two recent examples where the issue arose, Libya versus Syria. Libya. I have here in my notes that the head of state of Libya was a little bit Meshuggah. I probably shouldn't be so informal here, but he was at least disliked, outside of the African continent at least. Inside the African continent, it's another story. He probably could easily have gotten, by the way, asylum in South Africa, particularly because he supported the ANC long before it became fashionable to do so in the West. But he was disliked generally outside of Africa. Other than oil, and the calculation, wrong as it turned out to be, that the oil would flow anyway. In fact, the oil industry in Libya has been literally decimated. It was down to, I don't know what the current numbers are, but a few months ago at least, it was down to 10% production. It isn't actually decimated, it's more than decimated. It's 90%, 90% of it has been cut off. But nonetheless, the thinking was that the oil would continue to flow no matter who ran Libya. There was no calculation made for what if nobody ran Libya. So beyond that, there seemed to be no particular strategic interest on the part of any of the P5 countries. China might have asserted some interest because it has more to do with, had more to do with Libya's oil interests than others, but again, it seems to me the calculation was the oil would continue to flow. It's true that Muammar Gaddafi and his son, Saif al-Islam, had made threats to use force against civilians. But at the time that the Security Council authorized action, the numbers of civilians dead in Libya had reached only, I put the word only in quotation mark, hundreds. At which time the Security Council passed Resolution 1973 to protect civilians. Now, we of course know that 1973 was in fact used to oust the previous regime, and we also know that when it came time to deal with Syria, Ambassador Vitaly Churkin, with whom I dealt extensively when I was at the United Nations, in fact, more or less said, you fooled me one time in Libya, you're not going to do it again. Was he really fooled in Libya? That's another story, but that's what he said in his explanation of vote after the first veto. Well, we know the tale of what occurred in Libya. Syria, as we sit here today, we crossed the 100,000 mark of those killed, the 100,000 killed mark, months ago. Months ago. We are well on our way to 200,000 civilians killed in Syria. There's been no action taken, certainly not by the Security Council. There has been no action taken by any state. No arguments made by any state that customary international law, notwithstanding the deadlock on the Security Council, allows it to protect civilians in Syria. The recent threat of the use of force in the fall, or late summer and fall, had to do, in my view, not with 1,500 additional civilians killed as opposed to 100 150,000. It had everything to do with the fear of a proliferation of chemical weapons to non-state actors in the event of the demise of the Syrian regime, which certainly doesn't look like it's going to be demised anytime soon. Both Libya and Syria, by the way, had been accused of being state sponsors of terrorism. Libya in the past mostly, Syria now, and yet again, action in Libya, not in Syria. Well, very quickly, I mean, I think you could make an argument that to the extent the US, UK, and France were interested in acting in Syria at all, if they really were, as opposed to merely making the show of going to the Security Council, knowing that there would be a veto. If you want to be cynical, I don't know that I'm quite that cynical. But nonetheless, you could make the argument that it was a pro-Iranian regime, a pro-Hezbollah regime, and that these things were obnoxious in the nostrils of Western powers. In the case of China and Russia, they both are asserting or reasserting influence in world affairs, and I would say both powers, and now I have to, because I'm going on too long, I have to stop, but both are interested in checking particularly American power, particularly in the region, and Syria is much closer to vital economic interests, both of Russia and of China, than Libya was. They're much closer to much more oil than Libya. The point is that it seems to me you could analyze both Libya and Syria purely in political terms and forget international law, forget the treaties, forget much of what we think of as international law, and assess both purely in political terms and arrive at the results that in fact obtained in the two countries. If that's the case, if it is politics, then, and don't misunderstand me, I am not advocating against international law. I am merely, as a one-time sort of upfront practitioner of the craft, whatever the craft is, observing that the politics mattered much more than what international law was, and that's the world we live in. Is it the world we should live in? I'm a lawyer. I'm all for more law. But it isn't the world we in fact live in. Maybe we'll get there, but we're not there yet. Thank you.
Thank you, Ambassador. Professor Dutton?
Yes, thank you for inviting me, and thank you to our audience for coming here today. And I look forward to hearing your comments about this very interesting topic. So I'll start by saying that I study international criminal law and international human rights law. And so when I think about effectiveness of international law, it's precisely in that context that I am focused on. And so I start by thinking, well, there's a host of international human rights treaties out there. And the vast majority of states, as you probably know, have committed to a great number of them, to some more than others. But for example, nearly every country has joined the Convention on the Rights of the Child. Nearly every country has joined the conventions on eliminating racial discrimination and eliminating discrimination against women. Some 150 countries have joined the Convention Against Torture. And so I'll let you think, and I'll return to this, about how well you think various countries are doing on these fronts, because you can sort of imagine what these treaties propose in terms of protecting human rights and protecting against abuses of human rights. So I ask on this question of effectiveness whether these treaties and others like them are or can be successful in positively influencing state behavior in a way that furthers the goals of those treaties. So I think, and perhaps this is something of an oversimplification, but it helps us to sort of discuss this issue, Generally speaking, I would view the goal of these international human rights treaties as improving a state's human rights practices and its protections against human rights abuses. So I seek, and I have tried to do this empirically, and I'm still in the process of trying to do this empirically and perhaps through case studies as well. I seek evidence that the treaties themselves, as opposed to something else, are actually making a positive difference, because I start from the premise that, well, we must have created them for some reason, and presumably that's the reason, and I'd like to see that it's actually doing something that. Well, now one problem, and I think Judge Donoghue obviously referred to it, proving cause is always difficult, whether we're talking about in a case study context or in a sort of larger and empirical study. It can be difficult to isolate some precise causal factor. Sometimes that's because it's hard to conduct the study in a way that can isolate that, and sometimes it's because we don't always do something for just one reason, right? Perhaps a number of factors combine to cause us or a state or its state's leaders to do something that they're doing. So that's one overarching sort of large problem in terms of testing and quantifying, perhaps, effectiveness. But we can also just sort of think about this, and this is one way I think about it. Let's think about categories of states in this international human rights context. So think about what I sometimes call the good states. So states that maybe already have good practices. So think of some states in Europe or some of the Nordic countries or something like that. Well, many of them have joined these various human rights treaties, and probably when they joined, they already had pretty good human rights practices. And so this sort of ties into something that Judge Donoghue was saying earlier. So, and maybe after they joined, years go by, maybe they even grant further protections for women, and they protect women's seats in parliament and things like that, and some of them do. But can we say that the reason that they've done that, they've added these additional protections and they've improved their human rights practices, is that because they belonged to the treaty? Or was it already something that was a norm that they believed in and something that they were going to press forward with, whether or not they had some sort of international law binding them to this? Or was it not a norm? Was it because they decided, they did some study in the country that said, well, if we have more women working or more women in positions of CEOs and things like that, we're going to be a more successful country and we're going to make more money? What were their motivations for these things? So even isolating those things can be difficult in some category of countries like that. There could be different motivations. Now, maybe we're not even that worried about what causes the Norways of the world to get a little bit better, and we're maybe not so concerned about them when we're talking about the effectiveness of international human rights law. Maybe we're concerned about the countries that I call the bad countries, the countries that have really bad practices. Perhaps our goal in having these treaties was to have those states commit to the treaties, and that somehow this treaty would help them or cause them or make them improve their protection against human rights abuses. And so that's a category of countries that, of course, particularly interests me. But do we have evidence that those states, those ones that I call the bad states, actually improve their human rights practices after they join these international human rights treaties? And here there are a number of these studies. Political scientists and lawyers have conducted empirical studies trying to figure out, with different treaties at different times, have states improved their practices? And the evidence is actually mixed. There's a number of studies. It's still a handful. There's probably less than 10 that have really tried to do this empirically, look at whether these treaties are making a difference. Well, some have found, yes, some states seem to be improving, but others have found, no, these treaties don't seem to make a difference. So perhaps we don't have an equivocal answer right now in terms of scholarly work. That does mean, in part, that it remains an area where we can all continue to study that question. So that makes me think, well, despite all the studies, I still think that I can think of a number of countries out there that belong to all of the 6 main international human rights treaties, amongst them the ones that I named. And so, for example, Libya and Syria are members of all 6 main international human rights treaties. I think most of us could probably agree that they don't have the most stellar human rights practices. And so that gives me some pause and makes me wonder whether international human rights treaties are making a difference. But it also makes me start to question, well, is it something about treaty design? Is it something about the way these laws are crafted that might help explain why it seems, at least anecdotally, that perhaps they're not making a great difference in at least some cases, some instances that we can think of. So that's where I start to talk about enforcement mechanisms. I focus some of my research on treaty design and enforcement mechanisms. And so when I talk about enforcement mechanisms, I'm thinking about, is there something in the treaty, what does it contain to make states be held accountable? Is there some sort of mechanism? Is there some sort of accountability mechanism? And what exactly is it? And in the human rights context, in terms of at least the 6 main international human rights treaties, I think most scholars would suggest that they have been designed with relatively weak enforcement mechanisms. What they require generally is that the states that join have to self-report every 4 or 5 years or something like that to a committee. They're supposed to write sort of a report saying what have been their efforts to implement the treaty terms and to sort of achieve its goals and things like that. But the committee to which they write these reports doesn't have any powers actually to punish any non-compliant or bad behavior. And in fact, if a state doesn't file a report, the committee can't do anything about that either. And so another thing that I've sort of looked at is what is the reporting behavior of states, and in some instances, there's a number of states who have missed reporting periods for, 15, 20 years and ongoing. And so they've joined the treaties, but there seems to be not, in my view, a very strong mechanism to hold states accountable. Now, there are other international human rights treaties that have what I would characterize as stronger enforcement mechanisms, not completely as strong as some of the things we think of in a domestic context where we can actually go arrest people and put them in jail and things like that. But some, for example, allow individuals to file complaints and lawsuits against the state alleging that the state has not fulfilled its obligations under the treaty. And so I would say that that's a stronger mechanism. But then the question becomes, and it's something that we can discuss, will states join an international human rights treaty that requires them to do more, that makes them more accountable, that contains a more difficult sanctioning mechanism, something that requires them to do more? And since they don't have to join it, and my own sort of review of which states have joined various treaties suggests that there are fewer members of those international human rights treaties that start to require these mechanisms, like allowing individual lawsuits and things like that. And so this poses the question to me. I tend to be, well, I'm a former prosecutor, so I tend to be in favor of stronger enforcement mechanisms. But does that put us in a bind here? If we have stronger enforcement mechanisms, do we face a situation where the states that we think most need to improve their rights won't even bind themselves, to the extent that binding is anything, won't even bind themselves to international law, so that we don't have that mechanism at all to help them improve their rights? Or is it better to structure treaties with some sort of stronger mechanism so that they perhaps have the potential of actually holding states accountable and in some ways perhaps forcing them to improve their human rights practices? One other thing that I'll throw out is I can also envision, even though I'm the one who raised, of course, that there's still all of these bad states out there, Does it mean that they haven't improved at all, or does it mean that international human rights law has not been effective at all? Again, it goes back to that's a very hard question to answer because it's very hard to find evidence in that regard, and it may take us years. So another thing I like to think about is how long might this take for us to see the evidence that these things have made a difference? And even if their enforcement mechanism perhaps is weak, are we seeing some multi-factor influence on states? So for example, I can think that even though an international human rights treaty only requires a state to self-report, maybe the very fact that that state has become a member of that treaty over time starts to put some sort of additional pressures on the states. For example, NGOs can use that membership to start to criticize the state and perhaps take that membership and say, well, you're a member of this, so you should be doing this. Or its own civil society starts to expect that there's a norm in this regard. And so maybe there's some sort of, even if it's not effective, international law is not effective immediately in demonstrating an improvement, is it effective in sort of expressing the existence of a norm and putting us on some sort of path towards improvement?
Okay. Thank you very much. And let me thank all of our panelists for sharing those thoughts with you about effectiveness. And I think you've gotten an excellent sense of both the breadth and the complexity of the issues that connect with the question about whether international law is effective. Part of this has to do with institutional issues. Institutional design might be one question. There could also be a question, I think as Ambassador Istrabadi's remarks indicated, where you have potentially a conflict between an institution working as designed, the Security Council, conflicting with concerns that certain primary norms are not being enforced or not being respected in terms of the behavior of states. It's also interesting in terms of Judge Donoghue's remarks about the ICJ, how little we actually know about the effectiveness of ICJ judgments. It would be interesting to hear what your thoughts are with regards to why the academic community hasn't explored what seem to be some very, very basic questions, and what might be the rational calculation on the part of either international lawyers generally or the academic community that aren't focusing on these issues. Are they not framing these issues as questions of effectiveness, either of the primary norms or the institutions themselves? But it's question, answer, and discussion time, so I'll throw it open to the audience now for you to ask the panelists questions or to make comments about the topic at hand.
I'll venture to represent the political science community. Going out on a limb. There is one area of international law, at least. It's not specific in my field, so I can't really say much. But there is one area where I know that research has been done with regard to the effectiveness of international law, or at least the impact of international law. And that may not be widely played out, may not be the same way. And that's the area of the NPT. And NPT signing and compliance. And there has been some work done to, particularly in the cases of states that lagged in signing the NPT, to determine, well, what finally got them on board? Or what finally got them to abandon the programs that they held on to for a while that would have contradicted the obligations under the treaty, and then got them to give up those programs. And one of the nice things about some of this research is that we can identify some cases where decision makers will actually say, or you might say confess, we signed, and I have in mind particularly South Africa, but also Brazil and Argentina, we signed because it was important to us to obtain international legitimacy. And because it was in our interest to be regarded as compliant. And I'm just wondering whether in any other areas of treaties or international law, you ever have such nice cases where decision makers will say, we did it for this reason, and if there are such cases, when the decision makers say that, can you really believe them that that was the important motivation?
Does anybody of the panelists want to respond to that? I mean, I'll certainly take a first crack at it, because there are situations, I mean, this is part of the problem with analyzing the effectiveness of international law given the scope of issues that international law covers. So you can find specific instances where it seems as if you're zeroing in on some answers to some of these more difficult questions. But part of this has to go to sort of reading the mind of the state when it says it's done something for a particular reason, when in fact, that's not the reason that it actually did things. And I can think, for example, you can think about this in terms of the context of the Biological Weapons Convention. A similar sort of dynamic and statements have played out, but there has been some research done to the indication that governments have realized before they sign that their biological weapons is a military matter useless. So they've already made the decision to disarm themselves with regards to biological weapons. They can make it look as if they're supporting the international community and the legitimacy of the norm that they've already decided in their raw self-interest that they were going to go in a different direction. So it's a win-win for them, but it complicates analyzing whether the existence of the norm has this causal impact on the behavior of states. A flip side in terms of that sort of effectiveness is people who look at international trade law and the World Trade Organization. And there you often get complaints that it's too effective. Right? The states are actually following the norms, and that's creating problems for other areas of international law or other norms that are outside the objectives of trade liberalization, human rights, environmental protection, labor standards, what have you. And so it becomes very difficult to talk across international law when you have so many of these different types of case studies that you have to break down, including case studies that apparently aren't being broken down. I don't know if other panelists want to respond at all to that.
I don't mean to sort of step on your toes. You talked about human rights. And certainly, I don't know about what leaders say about signing on to human rights treaties, but we certainly know that there's not a human rights treaty that most dictatorial and authoritarian regimes don't sign on to. Saddam Hussein's Iraq was a signatory and a ratifier or an acceder to all the more international human rights treaties than the United States has ratified or acceded to. But it certainly we know that that in the bad states there's a very attenuated, to be generous, there's in fact no relation, no cause and effect relation. But it is considered, de rigueur, that of course you will sign these treaties and say that naturally all of these norms are respected by your government.
Other questions, comments? Oh, thank you.
Yeah, I'm curious about the enforcement mechanisms that you talked about, but before we even get there, I'm more interested by the front end. How do we attract courts and the law to certain areas of the world over others? Because it seems like there's a lot of strategic areas and countries and regions in the world that attracts courts and nations very quickly, and they respond in a timely manner. But there's a lot of countries and regions that don't so much. For example, in Uganda, there was a war that started in 1987, and the courts did not respond until they first indicted a war criminal in 2010. And so it seems like some areas of the world there's more of a lag time. I'm wondering, my question is, how can those areas of the world attract courts' attention? How can they respond? How can they attract a legal response in a more timely fashion? A lot of countries, maybe in the Middle East,
I'm not sure that I completely understand the question, and I apologize for that. but let me sort of use the opportunity to paint what I think might be a slightly more optimistic picture than might emerge from some of the comments on this panel so far, by giving one example, which this is a hard area because we don't have information. We don't know why states do what they do. Even when we know what happened, we don't know why it happened. So I have felt, and I've been thought about effectiveness quite a bit since I worked on designing environmental regimes in the 80s and asking exactly these kinds of questions. Well, what's an effective regime? What are the trade-offs in terms of drawing states in or having them stay out, et cetera? These are hard questions, and it's hard to know what the right answers are. So here's my slightly optimistic story. And to start off sounding pessimistic. The Convention Against Torture, which was mentioned earlier, important human rights treaty, the first state to ratify it was Senegal. Senegal, not too long thereafter, the former dictator of Chad, Mr. Hissène Habré, was essentially given refuge in Senegal. So he was in Senegal. He was alleged to have tortured a lot of people while he was dictator in Chad. And under that convention, Senegal had an obligation to prosecute him, or if it chose not to do so, to extradite him. But it didn't do so. And in fact, it didn't enact any implementing legislation under the convention. So eventually, when there was an effort to prosecute Mr. Habré, that was found to be ineffective because there was a decision in Senegalese courts that there was no domestic law that provided a basis to prosecute Mr. Habré. So far this sounds like a very bad story. Some human rights groups and some victims groups remained vigilant about this, didn't lose sight of the problem, and among other things, worked with Belgium. Belgium brought a case against Senegal in the International Court of Justice, saying that Senegal has an obligation to prosecute, or if it chooses not to do so, to extradite him to Belgium. We considered that, and we decided that Belgium was right. So we ruled that there was an obligation, as I said, to prosecute, or if it chose not to do so, to extradite him without any further delay. Okay, that happened. And soon thereafter, Senegal, working with the African Union, established a special chamber which began the steps towards prosecuting him. Habré had been had been at home with some surveillance before our judgment, and soon after our judgment he was taken into custody. So lots of things happened after our judgment, so that sounds pretty good. But I think we have to keep in mind that other things happened around the same time as our judgment. The government changed in Senegal. There was a change in the government that coincided with our judgment. A particular minister, I think she was a justice minister, repeatedly spoke about the importance that she attached to this. And again, as I mentioned, one particular human rights group remained vigilant throughout. Governments put money into the prosecution. The U.S. government put money into it. Near the end of Secretary Clinton's tenure, when she went to Senegal, she announced a contribution. The European Union put money into it. The Belgians put money into it. The African Union worked hard with Senegal. So what this tells me is it takes a lot of moving pieces for there to be progress. And so I'm happy that I think, pretty strongly guess, that the decision of our court contributed to this outcome. I feel pretty certain that we did. But I also know it wasn't the only factor. Maybe if there hadn't been a change in government, we wouldn't have seen this progress. So I would just say it takes a lot of things happening at the same time in order to see change that can be attributed, at least in part, to international law and international institutions. So as I said, it's a slightly more optimistic picture than we might have heard before, but one that still requires constantly a recognition that this is a difficult subject to study, and that progress may appear quite incremental at times.
There's also a difference between the way different regions around the world look at and think about international law with regards to trying to construct a common approach to different issues. And that regional variation often runs headlong into sort of the universalism of some of the norms which are embedded in international law. And you can think particularly of human rights as a classic example of that. And it's this sort of constant feedback loop between sort of the universal energy that comes along with some of these norms, interfacing with these different regional approaches. Europe's very different from Asia. Asia's different from Latin America. Latin America's different from Africa, and it's the combination of that variation with this universalism that generates this constant churning with regards to doubts about or activism for increased enforcement or increased compliance or increased effectiveness with international law. And at the end of the day, and I think a lot of international lawyers would admit this, it is about politics, and international law was never really designed in any other way than to operate in that way. The question is, how do we change the politics? But part of that question is what are the roles that the norms themselves play in connection with the institutions. And for me, that's part of the reason why we have these constant questions about different regions of the world and why they don't look the same as other parts of the world. And it's part of the constant progressive development, if you will, of international law, both in terms of the norms and the institutions.
That was very helpful. As I was thinking about this, it seemed to me that part of the reason this is so complicated is that you've got a very I was thinking of a very elaborate two-dimensional matrix here, with one axis perhaps being the sources of international law. We talked about here some international adjudication and then treaties and other positive international law and customary international law, and then different measures of effectiveness, right, from voluntary compliance or deterrence or some type of actual enforcement mechanisms. But maybe it's three-dimensional, and maybe the norms that animate all of these sources of law make it three-dimensional. In some of these areas, the boundaries in this matrix are not very clear. I was wondering, would if you got to the point of having to enforce an international judgment, a state did not comply with an order of Your Excellency's court, would any of the reforms that are sometimes talked about in the Security Council be of any benefit to that?
I'm not aware that any proposals for Security Council reform would directly address the role of the International Court of Justice. I think that the whole idea of enforcement of our judgments is an interesting one to reflect on, because I think that when people ask about that question, when people think about that question, implicit in the question is an expectation about the international legal system. It is born of our training in our domestic legal system. What I always then try to think about is, I often say, my court is known by the nickname the World Court, but there's no world government. So you can't expect the World Court to have mechanisms associated with it that look like the kinds of mechanisms for enforcement that we have in a national legal system. And so sometimes I think that some disappointments about the gap between outcomes in international courts and changes in behavior are a consequence of the fact that people are imagining that the World Court will do all the work of a government, whereas in fact we've got this thing, we've set it up as a World Court, but we don't have an international sheriff, we don't have a U.S. marshal, we don't have an equivalent of the marshals. We don't have those mechanisms, so it's certain that we won't see the kind of what might be called enforcement at the international level that we are
accustomed to seeing domestic, those levers just aren't there.
So you've spoken a lot about violence and international law effectiveness and effectiveness preventing violence. And you also mentioned a little bit about some trade laws being too effective. So if you have international trade law, on one hand being too effective, international human rights law on one hand being ineffective, are there other areas where we see some effectiveness or lack thereof, or how do you, that might shed light on how the international norm is created?
Well, for me, this is part of the problem of talking about the effectiveness of international law, because I'm sure you're all aware, international law in this day and age covers so many different topics in so many different ways, with so many different institutions and processes, that being able to hold constant the constellation of variables that we would want to do across this becomes very difficult. What you tend to see are sort of some leading case studies where people say that's a complete failure, international law is totally ridiculous, and so we ought to forget about it. Versus other, and I use the World Trade Organization, international trade law is one area where people have said it's too effective because it allows the choice of one particular objective, trade liberalization, to trump other values and interests that we would like to see more effectively reflected in the system involving the regulation of international economic activity. And that's not to say people think, and then you get debates about whether or not it's effective or not, but it's certainly perceived to be more effective than many areas of international law. But you could talk about foreign direct investment. You could talk about lots of different other areas where we could find examples where things are falling apart, or examples where things are holding together quite well. And then to try to connect that horizontally across this becomes extremely difficult. And so this, I mean, for me, this is not anxiety. This is more probably the frustration reaction. Sometimes it's effective, sometimes it's not. I mean, it's not a very satisfying answer, but to some extent, I think that's the empirical reality of this. And I think part of what Judge Donoghue has done for us is to remind us that some of that heavy lifting to maybe begin to connect some of those dots simply isn't being done, either in the practitioner community as it affects making arguments in this context, or in the academic community as we try to think about these issues. I don't know if any of the other panelists have thoughts on that particular question or issue.
I had a question about sort of your reflections on perhaps the philosophical or pragmatic implications of uncertainty. This is mostly for Professor Dutton and Donoghue, because start with, I think, so Professor Istrabadi makes a powerful claim that this is not an effective instrument when dealing with violence. There are scholars who disagree with that. I think even they concede that this is the weakest part of the argument. I think perhaps the best defense people raise against this view is not that you were wrong, but you were only right about this. As Fidler sort of suggested just now, it's something about violence and its existential risks and opportunities is just different. The law is never going to speak there. But that leaves the other areas, which adjudication, human rights that you spoke about, and I heard from both of you elegant descriptions of extreme uncertainty, a list of questions, right, doubts about whether treaties work or not. And of course, beyond that, this is especially true, say, in a field like international criminal law, as you know. There's the counter possibility not only of uncertainty, but that there may be negative externalities, real costs to these enterprises. I don't know how true that is for human rights. Some theories about that. But international criminal law is a very live set of claims, although I would suggest equally uncertain proofs. So what I want to ask is, this may not be a question that we can answer with further work. People have certainly tried. This is not an empty field. There may be something about the complexity and political nature of these fields that this is unanswerable. If that were so, what are the strategic, ethical implications of this for how we act? Should we refrain from judging some matters? Should we not press certain kinds of issues? Should we nonetheless proceed and do something even though we have no idea? I think in domestic law we have a range of responses to this. Sometimes we don't act when we don't know the cost and the benefits. How how do we respond to that uncertainty if it's endemic?
Well, in terms of international human rights law, I agree with you in the international criminal law context, we're concerned the peace versus justice debate and all of that sort of thing. There is a little bit of political science literature that suggests perhaps that one externality you could have with respect to international human rights treaties is that some dictatorships, for example, will sign on to them, sort of signal legitimacy, and kind of use it as some sort of shield and just be worse than ever because at least they can say, oh, I have this out here, I've signed on to this, I'm really good, but go do whatever they want. Do I think, well, one, I mean, people can question whether that really happens or not, because of course this is sort of a theory and then proven by some sort of empirical research. Dictators don't really actually confess and say, yes, I signed this, and then I went and became more repressive on my people on purpose. So we don't have really great evidence in that regard. Do I think that it's a reason to abandon international human rights treaties? I don't think that I would. I don't see enough harm in it, and I tend to, even the story that Judge Donoghue told about the Hebraic situation makes me think that it's worth having them, and it's sort of one of the things that I mentioned. It's hard to identify a causal factor, but to the extent even that these treaties are there sort of in an expressive fashion, expressing that these are norms that most of the world agrees should exist, even if it takes over some long period of time, and some group of citizens or victims or NGOs will grab onto them and keep pushing that dictator to improve practices because of it. I think it's still worth doing.
It's an interesting set of questions. When I was working on international environmental agreements for the State Department before the Rio Earth Summit, I had the sense that advocacy groups were constantly coming into us, negotiate this other treaty and conclude this other treaty. It's important to do these. We've got to do these. We need more treaties. And I kept wondering, well, are they really putting their resources in the best place? So we'll have a bunch of treaties. States will go to Rio. They'll celebrate these treaties. They'll become parties to them. Will they affect outcomes, or should the environmental groups be putting their emphasis somewhere else? So when you choose to pursue treaty creation, it's at the cost of not pursuing some other environmental advocacy agenda that they could have pursued. In the case of adjudication, I actually think that what evidence we have would suggest it should continue. That if I'm right, and in the efforts to look at our cases would suggest, I think, pretty strong sense that they have affected outcomes, that they do matter. And one other measure of that is states choose to initiate adjudication. I mean, they're not doing it because they think it's fun. Sometimes there are lots of reasons why a state might think it is a good idea to put an issue into adjudication, but settling the dispute peacefully is often an outcome of that decision to do that. For me, when I think about my job as an international lawyer, I think one of the most important tasks for an international lawyer is to offer a menu of options for solving problems other than the use of force. So having international adjudication available as a way to address problems seems to me to be very important, and I think the record would probably suggest that it has made a contribution. Almost all international disputes are settled in a manner other than through adjudication. There's no doubt about that. But to the extent that adjudication can contribute to addressing some problems, big or small, I think that is incrementally quite valuable to a world that is one that we, I think, all seek, one where we reduce the risk that people will settle the disputes by killing each other.
I mean, I don't think it responds directly to the the concern that you've raised about uncertainty, but one of the things that's always struck me in both participating and trying to help non-state actors or state actors deal with uncertainty or watching this happen elsewhere, that despite this long-standing and continued question about the effectiveness of international law and doubts about it, international law remains extremely useful. So in dealing with uncertainty, you see states, intergovernmental organizations, non-state actors constantly returning to international law as a means of navigating through uncertainty, often without necessarily expectations of effectiveness on the back end. And it seems to me to be odd that we have this conversation about effectiveness when international law in so many situations seems to have significant utility for all the political interests involved.
Judge Donoghue, you told a story, talking about the Senegal situation, you told a very positive story about a situation when a multiplicity of actors and actions contributed to a positive outcome. So, you know, your court's judgment coincided with the change in the regime and the continuing involvement of NGOs and so forth. And I'm wondering whether there are situations when the fact that multiple actors, multiple institutions are involved in seeking to enforce compliance with various international law norms actually complicates rather than assists the effectiveness of those norms. And, you know, I guess I'm thinking in particular of situations where there can be multiple tribunals involved. So, you know, the recent, you know, soon coming to an end, but the spate of cases where human rights NGOs worked through the Alien Tort Statute to get American domestic courts involved with enforcing human rights norms. I mean, are there situations where that kind of overlap in enforcement mechanisms can actually complicate the task rather than assist it?
Yeah, I mean, definitely. You know, there's a big literature about that for a while, and judges of the International Court of Justice, this was before I was on the court especially, seemed very concerned about proliferation of courts and mechanisms. And I guess my own reaction, watching it from the outside at the time, was to wonder whether they were mostly just feel some of them might have felt threatened by those developments. But it also has always struck me that it's inherent in the international legal system, that it's a very decentralized system, and there's no way to order it from the top. So I think it can be a problem and will be a problem. It comes up all the time when you've got some sort of crisis, and then suddenly you've got all kinds of groupings of states, so they have names. It'll be the Quartet or the D3 or whatever. They've all got nicknames, and they're circling around in regional groups and sub-regional groups, and the UN will appoint a special rapporteur and sort of collision course all the time, and it definitely can complicate things. But sometimes they kind of organize themselves in a sensible way, and eventually there is progress.
So how do we facilitate that? I mean, what are there common patterns in the situations that work and common patterns in the situations that don't? Or is this all just an issue-by-issue question whether the right constellation of, let's say, political interests and, you know, the involvement of the right institutions gets to the right result?
It's probably closer to very fact-specific, but I think one thing that I've observed over the years is where there is a dominant entity that asserts itself relatively early, that can be effective. Another ICJ case some years ago that is an interesting example of that is the settlement of the boundary between Cameroon and Nigeria. The court was decided on a maritime land boundary. Land boundary caused a change in there were people who considered themselves to be nationals in one state, and they were told, well, actually, you live in the other state, and that was complicated. And but before the court rendered its decision, the Secretary General convened the leaders of those states, and they before they knew what the result was going to be, they began to work collaboratively on mechanisms for implementation of the judgment. That to me seemed like a very clever idea, because it was an attempt to achieve buy-in from them before they knew where they were going to end up. And it took, I think, a concerted effort on the part of the UN and other states to work with those states to help them sort through the technical details, and of course there were sensitive political considerations for them domestically. And my sense is that it took some wisdom and foresight on the part of undoubtedly the Secretary General, who's from the region, but probably also those leaders, because it's hard to be to give up territory, to be told you're going to give up territory and to do it. But for our court, for example, we don't have any mechanisms to really interact in a formal way with other institutions, in the same way that if you might ask yourself, well, U.S. courts are engaged in alien tort cases, maybe they should pick up the phone and talk to somebody else. They won't do that. It's just not. Courts, we live in a somewhat more isolated world, so courts, I think, are especially challenged in collaborating with other bodies, because we're set up to function in a different way.
Well, in order to be an effective moderator, I'm supposed to bring this to a close at this point. Whether you've been fascinated, frustrated, or your anxiety about international law has gone through the roof, I hope you'll join me in thanking our panelists for sharing their time.